You're watching 13 WMAZ Law Call, sponsored by Macon law firm Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Hello and welcome to Law Call. I'm Morgan Dukes, your host for this evening. And tonight we have a very serious topic that we're going to be talking about, and that of catastrophic injuries and wrongful deaths. Now, no one likes to hear those words because they change your life, quite honestly. But tonight, to help us navigate our way through it, we have from the law firm of Reynolds, Horn, and Servant, Mr. Carl Reynolds. Hello, Carl. Good to see you.
Hey, Morgan. It's good to see you again. Even though we can't actually see each other, we're still doing this by Zoom. As we all know, we're still following the protocols of the COVID-19. And tonight's show is an interesting show as to the kinds of catastrophic injuries and wrongful death that give rise to causes of action. Now, we're really talking about the conduct of some party that causes an injury or wrongful death to someone else. If that conduct is negligent or careless and you can establish causation, then you have a cause of action or a right to compensation for the injuries done. It doesn't really matter whether they're minor injuries or major injuries. We're talking about the conduct that causes them. But to be completely candid, if it is a catastrophic injury or a wrongful death, they are handled in a somewhat different way. As to the catastrophic injuries, the first thing that people need to understand is they take a very long time because you can't make a recovery on any injury until the injured person has achieved what will be their maximum medical improvement. And you can't determine really the value of the case until that has occurred. Now, obviously on a wrongful death, that's different. There are different factors that are brought to the attention of the jury to determine the value of the life of the person who has been wrongfully killed. To answer most of these questions and do the heavy lifting, we've got B.J. Servant. He's been to the Court of Appeals numerous times and the Supreme Court to establish the law in some of these areas. B.J., we'll be asking you to take the first question, in fact.
Okay, glad to be here, Carl.
All right.
Well, hello, BJ. It's good to see you.
Morgan,
as always.
how are you?
Real
Good to see you as well.
Real good. Well, let's go ahead and throw you in the water because our first question comes to us from JJ. And JJ wants to know, what if someone dies from their injuries before they're able to even talk to a lawyer? Would their family be able to sue the guilty party on their behalf?
Well, the short answer is yes. Just because you die, obviously in a wrongful death action, the person dies before anybody considers consulting an attorney. And Georgia law is very specific in a wrongful death action as to who has the cause of action, that is the right to sue. If you're married, your spouse, and you die, your spouse has that cause of action. If you're not married and you have children, your children then have that cause of action. If you don't have any children and don't have a spouse, and your parents have that cause of action. There's some other, keep going as to who the proper party is, but yeah, they have the same right of cause of action that you would have had you survived. In other words, if you were able to, the same damages in terms of medical expenses would be recoverable by whoever survived the decedent. And other aspects of damages for the wrongful death would be the full value of the life of the decedent, and that would flow by statute to the people I just mentioned. So the proper plaintiff gets the bulk of the money typically, but if there are a lot of kids, there's a certain way it has to be divided up. But the short answer to the question is yes, it certainly survives the death because of action does.
Okay.
You might want to add, BJ, that if it's a wrongful death and there's a spouse, let's say if it's the breadwinner of the family, the man, and there's a spouse and 3 or 4 or 5 children, as to the wrongful death, the spouse will always get no less than 1/3. Is that correct?
That's right. And the children, no matter how many they are, divide the other portion.
Right. And then also in Georgia, there are 2 causes of action most times in a wrongful death if there is any conscious pain and suffering. That is a separate action that goes to the administrator of the estate. And that case will be brought along with the wrongful death.
Right.
They can be the same party, or you can have a different administratrix or administrator, or you can have the two cases brought by one party.
Okay. Well, you know, I want to ask you this question. We hear a lot about wrongful deaths or accidents that involve automobiles, but let's talk for a moment about those that might involve a pedestrian. You have any cases that you can share with us, or any information on how that would be handled?
Well, I think most lawyers who do this kind of work have had numerous cases involving automobiles and pedestrians. It's kind of like dart out cases. They come under a certain category, and they're not really, they're not great cases because it's almost always a question of liability. And that's what we were talking about in the T's. Just because somebody is injured and or killed, it doesn't mean they have a case unless they can establish fault. And fault is established by proving that the conduct of the person who caused the injury or death was such that it could be deemed negligent or careless. In fact, we have a video tonight, which I think illustrates the point. It involves a pedestrian who was leaving the Atlanta airport, coming home from a trip. He walks out of the building. He walks into the crosswalk in which he has the absolute right of way. And it's very quick, so you have to watch it. But if you look at this video, a car comes along at a pretty high rate of speed, given the traffic conditions. And as the pedestrian steps into the crosswalk, he is hit, knocked down. You can't see that from the vantage point of the camera. We got that from the airport. But he was badly injured. In fact, it was a catastrophic injury. Now, here's the amazing thing. The police officer who investigated it was called in by the airport police. They came in, investigated it, took a story from the driver of the automobile, and the next day went up to the hospital where the pedestrian who was run over had been admitted, and gave him a ticket for jaywalking. Now, that's true. That's what happened. Then we got these videos, and it showed that the pedestrian actually walked into the crosswalk and had the absolute right of way. So there's your proof of fact. And without that video, it would have just been a swearing contest. Mm-hmm. So again, it's always turns around the conduct of the parties and whether or not you can prove that conduct was negligent. Then that was a good example for us to use.
Well, thank goodness there was video, right? Thank goodness for that.
You don't always have a video.
You got that
You've always
right.
got some kind of evidence.
That's true. That's true. Always some evidence.
Sometimes you got eyewitnesses and stuff that will help you out. Oftentimes a person gets killed and then it's the driver's word against nobody, and that's what makes it difficult.
Oh, okay. Okay. Well, again, thank God for the video. Thank goodness for the video. Carl Reynolds and BJ Savant are our attorneys tonight. We'll be back with more of your answers to the questions that we have about catastrophic injuries and wrongful deaths. I'm Morgan Dukes, and you're watching Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney BJ Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, and tonight my attorneys are none other than Carl Reynolds and BJ Savant from Reynolds, Horn, and Savant. And we're talking about catastrophic injuries and wrongful deaths, a very serious topic because they generally don't end well, or they have life-altering circumstances that go along with them. But we do have some questions. And our question tonight comes from Jonas, and he wants to know that he's heard someplace that some states put a cap on the amount of money that you can win in a lawsuit. Is that true? And if it is true, what is what if the amount of your damages are so much more than the amount that's allowed? So who wants to tackle that one first? I mean,
well, there was a time in Georgia when we had a cap in medical malpractice. Our General Assembly, in its infinite wisdom, set the cap on wrongful death or non-economic damages, and later the Supreme Court struck it down. So right now there is no cap on non-economic damages in Georgia. And we've had several cases in North Carolina. There is a cap in North Carolina of $500,000 on any wrongful death case arising out of medical negligence. But BJ, you might want to address the history of the, was it Senate Bill 3 in Georgia?
It was, yeah. Yeah, it was, it's been a while now, but yeah, they enacted what they call tort reform. And one of the provisions of tort reform was to make it supposedly more attractive to businesses to come to Georgia because they're getting rid of all the damages that people could recover in lawsuits. And as Carl mentioned, that part of that was a cap on the damages as to pain and suffering, that sort of thing. And that the Supreme Court struck that down as a violation of the Constitution. So like you said, there isn't a cap on anything there now. There's still a cap as to punitive damages. That's kind of a weird cap because it's paid a certain way. And there's no cap if the damages are based on alcohol or drug use. But that's the only cap I'm familiar with here in Georgia. Other states, like Carl mentioned, North Carolina, I think Florida's got somewhat of a cap in med-mal. I'm not certain what it is. And a lot of neighboring states have different limits on pain and suffering or wrongful death or other limitations on damages. But the question also mentioned, what happens if your damages are far worse or more than that? And sadly, there's not much you can do if there's a valid statutory cap. You can't go over that.
Well, let me ask this question. Let me throw it to both of you. Well, what's the big difference between, say, a $10,000 or $100,000 case and $1 million case? Because if you were to listen to some of the commercials, you will really think that you can get a lot more, or you're insulted if you get a lower amount.
If I start on that, I don't know when I'll finish.
I was about to say the same thing. It's just, there's a lot of things that go into the value of the case. The one thing that should never enter the value of the case is what somebody on TV says the case might have brought, because you don't know anything about it. The lawyer might say, we got $500,000, well, the case might have been worth $10 million. You don't know, so it might just sound like a lot of money, but it's actually pennies for what they should have gotten.
Yeah, so, there's an old joke in the plaintiff's bar that you know how to get $1 million settlement. You start out with a $3 to $5 million case. Now, here's the reality of that joke, and it comes sadly to a lot of people who are in this situation. If you have a $3 million case, you're going to probably have to investigate it, file a lawsuit, go through all the discovery, go up to the point that you are ready to try the case and actually try the case. In some instances, you might try the case twice. We had a case, a med-mal case one time that we tried. The first time we got $1.7 million, $1.8 million, and the Court of Appeals overturned it on the basis of one of the jurors' answers to a voir dire question. So it came back and we tried it a second time. The second time we got a similar amount and it went up again. No. On the second occasion, one of the jurors who was a wino, we had several strikes on both sides, and both sides felt like this man would not be a factor in the consideration at the end of the trial. We were wrong. Both sides were wrong. We tried the case. The jury went out. This fella, they said, well, let's just see what everybody thinks and take a straw poll and everybody write down whether or not the defense is liable and what you think the case is worth, et cetera. And this fella just turned around, put his feet up on the windowsill and looked out the window and said, I don't have to do a damn thing. So the next day, after they'd been out for 4 or 5 hours, the judge called us in. He had gotten, I think, 4 or 5 letters from the jurors saying this man was a nut job and would not participate. Well, by this time, the defense kind of got they sensed that they were going to get hit again. So they could have agreed to take a verdict from a jury of 11, but the defense counsel wouldn't. So we go back a third time and try the case. And we got a verdict that was similar to the verdict in the first case, and that case was finally put to rest. But we tried the case 3 times. That's a true story. That happens sometimes.
Okay.
The case,
Well,
you don't ever know what it is. But my point was this: that case probably could have been settled for $500,000 or $600,000 before the first trial. So if you want to get the full value out of a case, you've got to be ready, willing, able, and prepared, not only to do the work that it takes to get to and through a trial and an appellate procedure, but you've got to be able to fund that case as well. And that always falls back on the law firm. So
all right.
when they talk about, I got $350,000 in my case, BJ's right. It might have been worth $1 million or $1.5 million. It has no relevance to the real value of the case, especially if it's somebody touting it on a TV screen.
All right. Well, there you go. Now we have our answer.
And as Forrest Gump said, that's all I've got to say about that.
Carl Reynolds and BJ Savant are our attorneys tonight. Catastrophic injuries and wrongful deaths. Well, that's our topics. I'm Morgan Dukes, and we're going to be back with more of Law Call. If you have further questions for personal injury attorneys, Carl Reynolds and BJ Savant. You can find them right here in Macon at Reynolds, Horn, and Savant. The telephone number is 478-405-0300. And you can also find them on the web at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds, Horn, and Savant on Facebook. There's lots of good information there. All right, gentlemen, we are back with more questions and more about the topic of catastrophic injuries and wrongful deaths. Now, listen, you hear a lot about catastrophic injuries happening as a result of an automobile accident. Can you share with us some other ways that people can find themselves in a catastrophic situation?
Oh, people get hurt in all kinds of situations. Medical malpractice almost always causes a catastrophic injury or wrongful death. Otherwise, you can't afford to handle it. Same with product liability. Those are very difficult, long and time-consuming and very expensive cases. There are just more ways than you can imagine that people get hurt. And we had an interesting one lately, and it involved the failure of a truss system. Now, truss is, those of you who are not familiar with construction, are the cross members that hold up the roofing on a building. And we had a fellow who was installing the truss system, and he was halfway down the 40-foot length of building where they were putting these trusses up. Well, he had to stand on the succeeding truss to put the next one in place. And as he stepped on it and they lifted the truss for him with a piece of equipment, the bottom broke and he fell about 12 feet on concrete and shattered both ankles, which doesn't sound like it, but it's a very disabling injury for a long period of time. And he called and we went and investigated it and found the lumber and the truss, the actual truss that had broken. And sure enough, the cross piece on the bottom had a knot in it that big. And that was what caused it to fail. And when it did, he fell and was injured pretty badly. And after our investigation and we got the actual piece that had failed, we brought in experts to look at it and got an opinion that should have been ruled out before it was ever put into that particular truss system. And we were able to make a good recovery on it, a substantial recovery for the injured person. And that's what I mean. That's not, when you hear all these people on TV, all you think about is automobile wrecks, but there are many other things that happen that cause people serious injury.
And
But I tell you this, you need not go to one of those people on TV talking about how much they got for the last car wreck that came into their office.
Okay, I'll duly noted. I will definitely not do that. I won't call them.
All
I
right.
will call you. How about that? If I ever need a good attorney. Okay, well, we do have a question.
I'll tell you that. Yeah.
Okay, we do have an email question from Olivia. And Olivia wants to know, she says, my friend was in an accident on I-20 and has had serious injuries. The driver causing the accident was from South Carolina. Will that matter when it comes time to talk to an attorney? That's an interesting question, because I'd like to know, was she, I don't know if this is a fair question, was she on I-20 in Georgia or I-20 in South Carolina? So does all of that matter?
Well, it might. Assuming I took the question initially to be I-20 in Georgia, in which case, if you drive into Georgia and have an accident that's your fault, the court has jurisdiction over you, even though you're not from Georgia. Georgia jurisdiction is usually people within that state, but it can expand its authority, the courts can, over what's called non-resident motorists, or people that were driving in the state of Georgia and due to their negligence cause an injury or death. They're subject to Georgia's courts. And one good thing about that too is the insurance that the car has. For example, in Florida, they don't have to have much insurance on their car. We have to have 25 in Georgia. I think they have to have 15 in Florida. But as soon as a Florida car drives into Georgia, their insurance company automatically provides them with our state minimum coverage. So their insurance limits, even if they're 15, actually go to 25, which will help the money that's there to recover from if there was negligence. If the accident happened in another state by a non-resident, you might have to go to that state, probably would have to go to that state to sue.
Okay.
And then their laws would apply as far as liability as well as damages, what you can recover.
All right. All right. Well, real quick, is there a statute of limitation on any accident like this? How quickly should they let you know that something is wrong?
Right away.
Right away.
Generally,
You always contact an attorney and find out. I mean, there's so many if, ands, and buts and exceptions to the statutes of limitation for minors, for people who are mentally impaired. In different states have different statutes of limitation. So you always want to contact a lawyer.
Yeah.
Right
A lawyer
away.
to protect your rights. Yes.
You got that right. And I've had two good ones with us tonight. BJ Savant, Carl Reynolds, thank you both for being with us, and thank you for answering the questions. Well needed. On behalf of all of us here at LawCall, we bid you a good night. And until next time, take care of yourself, gentlemen, okay?
Good night to you.
Morgan, good night,
Good
everybody.
night.
Night.